Well, good morning, everyone. My name is Giacomo Delledonne, and I'm a constitutional law scholar based here at Scuola Sant'Anna in Pisa. I'm one of the editors of Sant'Anna Legal Studies, STALS, a project and paper archive, and I'm very, very happy today to host this joint initiative that takes place thanks to a grant awarded within the Reconstitution Alumni Incubator Funds call. I would like to wholeheartedly thank Dr. Ylenia Maria Citino for managing all the efforts that were needed to make this possible. The title of today's seminar is Disintegration Secession Accession. We will have two main speakers, Dr. Oliver Garner and Ruth Polak, who have recently published monographs that are related to our general topic. There will be an intervention by Ylenia Maria Citino and two replies from our discussants, Andrea Gatti and John Stanton. Let me add just some words about today's speakers. Oliver Garner is a visiting lecturer in constitutional law, administrative law, and immigration law at City Law School in London. He got a PhD in laws from the European University Institute in Florence and a Bachelor of Arts in jurisprudence from the University of Oxford. He has long been a collaborator of the Bingham Center, and he has recently authored a monograph, Constitutional Disintegration and Disruption, Withdrawal and Opt-outs from the European Union, Oxford University Press. It was published in the month of May 2025. Ruth Polak is a tenured professor of public international law and international relations at the University of Salamanca in Spain. She teaches EU law, public international law, international relations, diplomacy and foreign policy, and human rights law. She has recently authored a book, EU Withdrawal as a Supranational Affair, The Case of Brexit. It appeared in 2023, and the publisher is Boyl. Ylenia Maria Citino is a postdoctoral researcher at the Scuola Superiore Sant'Anna. She got a PhD in constitutional law from the Università Roma III in Rome. She has been involved in a number of national and international research projects. She currently works at the Scuola Sant'Anna in the framework of a PRIN National Recovery Plan project. She has worked on artificial intelligence in parliaments, on the relevance of facts in constitutional law, as well as on several topics in European constitutional Our discussants are Andrea Gatti and John Stanton. Andrea Gatti is a postdoctoral researcher in comparative public law at the University of Padua. He got a PhD from the University of Pisa. A couple of years ago, he published a monograph on militant democracy in comparative perspective with a specific focus on France, Germany, and Italy. Finally, last but not least, John Stanton is an associate professor in law at City St. George's in London. He's also quite well known to an Italian audience, since he has contributed to quite relevant Italian legal blogs. So I'm very happy to introduce this impressive roster of speakers this morning. And so I think we can start, and I will give the floor to Ylenia Maria Citino. Thank you. 15 minutes.
So, thank you very much, all of you, for being here. I'm very happy that this seminar is taking part today. As Professor Delledonne anticipated, Reconstitution is research fund by the German Ministry of Research that gathers scholars and practitioners around Europe for exchanging analysis on the rule of law. So this is our first initiative concerning the grant that we were awarded a few months ago, and we will have additional initiatives. The next one will be held in Salamanca. So let me start with my introductory topic, as I will be discussing about European clauses in national constitutions. So this draws from my early research that I conducted in my postdoc in Lewis in 2022. So I've been working on these topics quite a lot. And let me first start with a metaphor by Walter Hallstein, was the first president of the European Commission. He said that European integration is similar to a bike in motion. When it stops, it falls. So this image, I think it captures quite well a mixture of centripetal and centrifugal forces within the EU. So before dealing with disintegration and accessions with Oliver and Polly, let's start with diving into the constitutional commitments that member states and new candidate countries are having in the European project. So in particular, I want to explore with you today how national constitutions reflect both the desire to join the EU and the effort to stay within the EU. Because the constitutional amendments that were made across the years in various member states, and more recently, of course, in candidate countries, reveal a layered story of constitutional strategy, constitutional positioning, legal adaptation, and also legal signaling their position to the EU partners. So I think it's important, prior to any description, to start with a definitional point. Because in literature, European clauses have been defined as the constitutional norms that acknowledge EU membership, that establish limits for the transferal of sovereign powers. So scholars distinguish between broad and narrow European clauses. The former reflects directly to EU membership and the delegation of powers, and the latter encompass a huge variety of provisions, for example, provisions regulating parliamentary involvement in EU affairs, financial obligations, or also the internal distribution of competencies between the constitutional bodies in light of EU membership. But what do these clauses tell us? First and foremost, that EU membership is no longer just a matter of international law. It's also something that has penetrated the constitutional core of many member states, creating something that has been described as a shared constitutional space or a matrix of constitutional convergence within Europe. So to further refine our understanding of European clauses, let's consider an interesting analytical framework. One of the early scholars that dealt with the topic, which is Monica Klaes. She proposed to distinguish between different categories of provisions that can be found in national constitutions, and these include, well, clauses that concern the basic membership of member states in the EU, which enable the transfer of sovereignty, clauses that impose substantive or procedural conditions for participation to the EU integration, and also other clauses, for instance, clauses regulating the appointment of delegates in the EU institutions. But I think it's quite important to limit the study of these clauses to only the clauses that enable the participation to the EU. So clauses with an enabling function. These are the most important one and the most relevant when we consider the legal obstacles to withdrawal from the EU. Because a state whose constitution has a similar clause would need to remove or to revise these clauses before proceeding with an exit process. And this is a fact that transforms the nature of withdrawal, because in this case, the withdrawal is not an international affair, it's mainly an internal constitutional law affairs. Let me now turn to two examples that embody different moments of this accession, disintegration, and integration continuum: Luxembourg and Ukraine. Well, Luxembourg, we all know, is one of the founding members of the European Community, yet, paradoxically, was one of the last to formally constitutionalize its EU membership. It wasn't until 2023, after a long sought, difficult constitutional reform, a total revision of the constitution, that Luxembourg introduced a full-fledged European clause, and in particular Article 5 of this new constitution, which explicitly affirms the country's participation to the European integration, allowing for the transfer of state powers to the EU by qualified majority. Until then, such transfers were justified through an implicit clause, what I call the old international law clauses, the clauses that were enabling the transfer of competencies to general, non-identified international organizations. Ukraine, by contrast, is a recent, particularly committed candidate, and since 2019, its constitution explicitly anchors the country's strategic goal of full EU and NATO membership in three key provisions. They have almost the same wording, and they involve the parliament, the president, and the government. The preamble itself speaks of the irreversibility of the European path. So this is a clear commitment. It's a tribal entrenchment, which is both declarative but also operational when Ukraine will become a member state of the EU. And this reflects a strong geopolitical commitment, especially in the context of the war with Russia. In Ukraine's case, the constitutional reform, we can say openly, served not just a symbolic or legal function, but also a clear geopolitical one, because it signals internally and externally that the country has definitely chosen its side, which is the European Union side. Beyond these two examples, there's a broadened pattern that emerges. Several candidate countries like Serbia, Montenegro, Georgia, Bosnia and Herzegovina have introduced similar clauses in their constitution, albeit with varying degrees of intensity, with varying degrees of legal weight. But what they share, what they have in common, is the strategic use of the constitution to lock in foreign policy commitments and to signal readiness to the EU accession. So many of these countries, they use constitutional clauses. This is what I mainly argue in my papers. These clauses serve some sort of reputational function because they are meant to persuade EU institutions that these countries have a genuine commitment to European values and to European integration. So even though these clauses are not required by EU law, they are not mandatory for the accession procedure, they can influence how a country is perceived, and also they can affect maybe the progress of the candidacy path. So it's also quite interesting to see that we can identify a similar pattern, though in a different direction, in member states that have added affirmative EU clauses after joining the EU. So we're making a step back. Look, for instance, at the case of Ireland, which is quite illustrative. Article 29 of the Irish Constitution states that Ireland affirms its commitment to the EU, describing it as a space for shared peace and prosperity. Or Croatia's constitution, which contains a similar enthusiastic declaration. These are provisions that reflect not just membership, but also a sense of identity, which is rooted in their belonging to the European Union. Okay, so we should not overlook also the other side of the coin, because if clauses can affirm this identitarian feeling of being part of the EU, they can also resist and affirm national identity. Several countries, and most notably Germany, Hungary, and Poland, have used constitutional clauses or their absence to set limits on European integration. These limits, as I anticipated, often relate to the protection of national identity, fundamental rights, or institutional competences. In Germany, we have the well-known Article 23 of the Basic Law, which provides for the legal basis for EU membership, but also empowers the Constitutional Court of Germany to review acts of the EU for compatibility with the German constitutional identity, the German Constitutional Tribunal. In Hungary and Poland, we have constitutional norms which relate to the EU legal order that have been invoked more controversially, in some cases to push against the EU oversight, as well as to promote sovereignty agendas. For example, consider the 1997 Polish Constitution, which was written with a view to EU accession. There are two clauses that are considered a basis for Polish integration, Article 90, Article 91, that refer in a general way to international organizations of which Poland is a member. So Poland does not have an EU clause as we intended. This paradoxically allowed for their constitutional tribunal to take a skeptical stance on EU integration mechanism, stating that certain EU laws are conflicting with the Polish constitution. You know, there's a very famous judgment from 2021. So in this case, such kind of clauses are not an instrument of accession, but are rather an instrument of constitutional resistance. And finally, I can mention also quite radical proposals to revise existing clauses. And we must, for instance, quote the French proposal from 2020, draft constitutional reform to modify Article 88.1 to allow Parliament to selectively disapply EU law through organic legislation. But we must consider also Italy, where the Parliament discussed but never approved several bills on revising or even repealing Article 11 of the Italian Constitution, which is considered the basis of the Italian accession, even though it is not also in this case a full-fledged European clause. It's an article that was originally designed for the accession of Italy to the UN, not for the EU. So we have also in our constitution other articles that quote the EU, but still Article 11 is considered as the basis for this. And Sweden also has seen many proposals to repeal EU-related provision. So where does this leave us in the broader debate on disintegration, accession, and secession? Well, my view is that constitutional clauses related to the EU integration are part of what we might call a deep constitution of the Union. They are not part of the EU law itself, but they form a network of domestic commitments when they have, of course, positive value that support or that in some cases may challenge the EU's constitutional legal order. So these clauses reflect the density of the European constitutionalism in each member state, and they influence both how integration unfolds and how crises are handled. So to conclude, European clauses are not a prerequisite for joining the EU, nor are they a guarantee for continued membership, but they matter politically, legally, and symbolically. They tell us something about how states perceive the EU, how they justify their participation, and how they envision their sovereignty in a multi-level constitutional system, whether used to enable accession, to deepen integration, or to resist further transfer of power. These clauses, I think that they reflect a fundamental dichotomy which is at the heart of the European project, one between unity and diversity, integration and autonomy, and ultimately also between constitutional convergence of values as well as national identity. I think this really embodies the seminar that we are having today. So I thank you for the attention. I leave the floor once again to Giacomo, and I'm really looking forward to your other contributions. Thank you.
Thank you, Ylenia, for this introduction. I have taken a lot of notes, and there will be food for thought during the Q&A session. Now it's for Polak Garner, please. 15 minutes.
Thank you. Can you hear me all right? Just to make sure I'm loud enough. Yeah, Giacomo, is it okay, the sound?
Yes.
Okay. I want to thank everybody for organizing this, Oliver for proposing the first grant application, and also for Ylenia and Giacomo for organizing in Pisa, and also for everybody participating. I thought, Ylenia, was very interesting, your presentation, and very good opening of this session. I wanted to explain a little bit, well, not entirely, my book, my monograph that Giacomo already mentioned, EU withdrawal as a supranational affair. But really what I want to explain, instead of boring you with all the details, is that I have now sort of evolved that initial thesis that I wrote as my PhD into what I am now calling the constitutionalization of EU withdrawal. So what's the difference between the supranational view and the more constitutional view, and how do we get there? That's what I would like to present to you today. So initially I defended the supranational nature of withdrawal in tune with the EU supranational nature. So because the European Union is a special supranational organization, I thought EU withdrawal should also be a special supranational affair and not just similar as any other sort of treaty exit. And I believe that this was confirmed by the Brexit practice, because it's also obviously based on what happened during Brexit. But as I then continued studying and reading these issues, I realized that the supranational nature of the EU and of therefore withdrawal, which basically places a series of legal and procedural restrictions on EU withdrawal that not necessarily exist in other sort of classic treaty exits, actually made EU withdrawal not only different to the case of exiting ordinary international treaties, but it also made it much more similar to the secession of a territory from its parent state. And so obviously by constitutional peaceful means, not sort of mobilizing independent parties by force. For example, so I'm writing a working paper on this topic now, and I give us as examples of how EU withdrawal is more similar to a secession than to an ordinary treaty exit. I mean, the level of sovereignty that a state regains when it withdraws from the EU is unprecedented. Now, it doesn't exist in any other international setting, and it might be similar to how a state gains its own sort of sovereignty from the parent state. Also, the impact that withdrawal has on the member state, but also on what we would call the parent state, or in this case, the international organization, all the remaining members, all of their citizens. It has massive ramifications, be they economic, political, legal, social, which also assimilates it more to a secession. There's no other sort of international treaty setting where this regaining of sovereignty and this impact on the entire legal, economic, political reality of the country and of the remaining members and the institutions doesn't exist in any other setting, except for if we think of secession. And then even the loss of EU citizenship, which is not exactly the same as losing the nationality of your parent state, but it is a massive downgrading of rights, especially in the rest of the union, no? Which could be assimilated also maybe to losing a nationality. This was already established by other other scholars, such as Dimitri Kochenov, wrote a lot about the downgrading of rights. So basically, my proposal is that the constitutional magnitude of EU withdrawal requires a similar constitutional framework as the one that is applied to peaceful constitutional secessions. And where do we find that framework? Well, my inspiration comes mainly from the Canadian Supreme Court's seminal ruling re-secession, when the Canadian court was asked if Quebec had a unilateral right to secede. It was told that it didn't, but not necessarily that it couldn't, but that it needed to comply with certain principles of the Canadian Constitution. And so my proposal is that EU withdrawal, because of that constitutional magnitude of the event, also requires compliance with what the organization or the union or the constitutional charter of the EU considers to be its basic principles. And curiously, they're the same as the ones that the Canadian courts have mentioned: the principle of democracy, the principle of the rule of law. I think everybody can agree that, okay, the EU is not a federation, so it's not totally applicable, but we can use it as constitutional inspiration, given, as I say, the situation may be quite similar, and that these principles that are in the unwritten, in the case of the Canadian Constitution, are in fact enshrined in the EU treaties. And I think by now everybody can admit that they are not just sort of mere political guidelines. They do contain legal obligations for the member states and the institutions, as the Court of Justice has now taken to reminding us now. So what would be the constitutional requirements of EU withdrawal? What does it mean, in essence, to operationalize these values, the principle of democracy, the rule of law, when withdrawing from the EU? What does it mean that a member state cannot just abide by its own constitutional requirements, but in fact has to abide also by the constitutional requirements of EU law? And how does that differentiate from my sort of initial supranational theory, or what happened in Brexit? Was there anything in the UK withdrawal that, with this new sort of constitutionalization of withdrawal theory, would have been unconstitutional or possibly need fixing in the future, if there are any future cases? No? So I contend that the first question is, would, for example, the principle of democracy require a referendum? Meaning, can a member state withdraw without a referendum? And I believe that the democratization of contemporary constitutional law or constitutionalism basically establishes that it is unavoidable to have a referendum when you want to touch upon such important sovereign issues and re-establish or establish a new legal order. So I believe that in the case of EU withdrawal, you need, based on the principle of democracy, a referendum, which, as we know, was held in the UK. But does the democratic principle also require this referendum to be designed in any certain way? So it's true that most of these referendums are a lot of practice. Every big sort of movement or decision when a certain population wants to decide upon its sovereignty or its independence, we will find that there has been a referendum backing, so it's also backed by the practice. But we also find that these referendums tend to require only a single majority. So I don't think there is any argument there that it would require a qualified majority. I do believe that there are certain requirements when it comes down to the franchise. And I think that we could easily see this or learn this from the Brexit referendum, where the franchise was designed in order to exclude certain voters that were actually going to be the most impacted by the decision. And this does not seem democratic in any sense. And I was excluded, so I also have a personal problem with this because of the 15-year rule. British citizens that live abroad, and I live in Spain, were not allowed to vote, and EU citizens resident in the UK, with the massive impact it was going to have on their life choices, were also excluded from the vote. This rule was established on the basis of the general election rule in Britain, which also had the same rule. So they just translated it also to the referendum on Brexit. And that rule in Britain has now been removed. So there is no longer a 15-year rule of non-voting. So if the referendum were held today, these people might have obtained a vote and they might have voted differently. So it's quite important how you design a franchise. The UK, maybe just because of this, would not now be or have left the EU, would not be an ex-EU member state. And therefore, how far can we say that this was the democratic will of the citizens, at least most impacted by the decision? I no longer have free movement rights and I wasn't allowed to vote. I think that's quite clear that it's not very fair, not democratic. What other requirements could we derive from sort of the constitutionalization of EU withdrawal? I also believe that a member state, in order to withdraw, has to involve not only the executive, but its legal and judicial powers. This is very interesting regarding what Ylenia was explaining about the national clauses, because it's true that Article 50 seems to only require this, that member states apply their own constitutional requirements. But then the question is, what are they? And this was definitely a question with Brexit because of the non-written constitution of the UK. But I'm going to ask Ylenia, when the questions arise, do they say anything about withdrawal? Because normally, as far as I can understand from her presentation, they talk a lot about how to accede and how to remain in the member states, and some of them are more positive or negative towards, but none of them seem to want to say what the rules are in case that they wanted to leave the EU. So it's quite surprising that Article 50 refers to the national constitutional requirements, and then in fact they don't entirely exist, or they don't seem to be in many or any member state constitutions. So in order to fill this void, possibly my constitutionalization of EU withdrawal could also require, on the basis of the principle of democracy, with which obviously member states have to comply, withdrawing member states also have to comply with them, would require parliamentary involvement. And obviously this is interesting in the case of Brexit, because everybody knows that the executive wasn't going to involve in Parliament if it hadn't been taken to court by Mrs. Miller. No? So this is also interesting from the point of view of backsliding countries in the EU, because of course you have countries that may involve their legislative and judicial powers, but they may not be entirely independent from the executive. No? So I also believe that we have to wonder if Hungary or Poland, in their current circumstances, triggered Article 50 on the basis of their own constitutional requirements, as Article 50 says. Would that, in fact, be effective under the EU law and EU's values? Because, as I'm proposing, you have to respect the principles of democracy, rule of law, Article 2, and of course, at the moment, they're not in general. So how could their institutions then respect those articles in order to trigger Article 50? I believe they couldn't. So basically what I'm proposing is that under certain circumstances, a member state could not actually validly send a withdrawal notification. And finally, also inspired by the secession ruling, what did the Canadian court ultimately say? That you could not secede unilaterally. And this is where there's a major difference, obviously, between secession and Article 50, because Article 50 does allow a unilateral secession, well, withdrawal. I do not know how to reconcile this with the rest of the treaties, with the EU's values, with the need to protect citizens, with the massive sovereignty restrictions that the EU would participation implies, with the level of integration, with the impact it has on everybody else. I mean, these were all the arguments that the Canadian court gave in order to forbid unilateral secession, which was, there is such a high level of integration throughout all of Canada that you can't take this decision. We're going to listen to your democratic will, but you can't take this decision without taking into consideration how it impacts everybody else's rights. So this was the Canadians' argument, that in order to channel the democratic will of Quebec through the rule of law, it meant that that secession had to be done with a sense of orderliness. That's what the Canadian court says. The Court of Justice, when it was asked to interpret Article 50, also referred to this aim of the clause of making sure that the withdrawal was orderly. So it sounds quite similar, the idea behind it, but I do understand that this kind of stretches the interpretation, possibly contra-legging, of Article 50. But okay, let's say that Article 50 allows unilateral withdrawal on a very sort of last resort basis, but you need to have a bona fide attempt at agreeing and making sure that everybody's interest and everybody who is impacted would be taken into account. So you need to negotiate that withdrawal. Could you justify, in the ultimate instance, withdrawing without any agreement and what was classically called a hard Brexit? I honestly don't believe that that is justified, even on the basis of Article 50, but that is debatable, of course. So finally, I don't know how many minutes I have left, or do I have any minutes left? 2 minutes. Finally, the question arises as what do the institutions do if they receive one of these notifications and some of these constitutional guarantees or requirements have not been complied with? Parliament has been curtailed, they've ignored a judicial sentence, or their institutions are not democratically sound, there is no actual real separation of powers. Well, my theory is that such a notification would be contrary to EU law, to the EU's values, and therefore ineffective as a matter of EU law, and the institutions could not consider it as a decision, and they could not consider Article 50 as having been triggered. This poses a lot of practical difficulties and questions, which I'm happy to answer during the Q&A session, sort of along the lines as, well, what if a member state says, hey, I've triggered Article 50, the 2-year period is over, and I've left the EU. And the EU, during all that time, completely ignored the notification because they didn't consider it was constitutionally sound. This kind of question, obviously, can be raised, but I'm out of time, so thank you for your attention, and I'll give the floor back to Giacomo.
Thank you, Polly. You have addressed a number of crucial issues, starting with the let's say, the choice of words, withdraw, secession, to constitutional lawyers, to international lawyers, to legal theorists. Both these terms, let's say, trigger different feelings. So about their unpleasant, revolutionary potential. This is, of course, above all the case of secession. And there is continuity with between your intervention and the introduction by Ylenia. So you highlighted the existence of a shared constitutional space, and that being the case, the withdrawal of the United Kingdom from the European Union is, of course, a supranational affair, and you have supranational constitutional requirements that must apply during the process and possibly after the actual exit of one member state from the European Union. So, Oliver.
Thank you very much, Giacomo. Just make sure everybody can see me. So the starting point for my intervention is this first phenomenon we cover in the title of disintegration. So similar to what Polly was saying there, focusing on withdrawal, but also disruption, as I call it in the OUP monograph that Giacomo mentioned at the start. I analysed withdrawal and opt-outs from the European Union. So these opt-outs were held by the United Kingdom, Ireland, and Denmark. And I will then extend the analysis from the monograph, from my PhD thesis, to some higher level insights about how this can help us understand accession issues and also bringing in territorial secession issues, because the common feature that I think holds these two three phenomena together is the role of individuals. And so individuals were the methodological starting point for the analysis in my monograph, and particularly what they play, what Jürgen Habermas called the role they play as a dual constituent role. So Jürgen Habermas, writing in 2012, argued that we should conceive of the European Union as being constructed by individuals playing the constituent role of nationals of one of the member states, now 27, 28 before Brexit, but also that they hold a co-constituent role as EU citizens. And this is a role that they constructed for themselves. And so in the book, I developed this somewhat into more of a dual legitimation role. So I argue that the equality between the two roles is only really prevalent in ordinary lawmaking within the European Union, in which individuals are represented by the European Parliament as EU citizens, and then the Council as member state nationals. Because crucially, disintegration, the fact that a member state has now withdrawn from the European Union, utilising Article 50 TEU, demonstrates that EU citizenship is not co-constituent in the way that Habermas conceived. It is actually fully dependent upon, one could even argue parasitic upon, member state nationality. And that's because of the fact that EU citizenship can be extinguished purely through majoritarian national democratic processes without requirements for example, representation or any voice for all other individuals who hold EU citizenship. And so I'd argue that this insight about the nature of EU citizenship is now very relevant for accession. We are currently faced with what can be called the Big Bang Enlargement 2.0, because we have that first Big Bang enlargement in 2004, Central and Eastern European member states. And now, of course, we have a situation in which the Western Balkan candidate states have been in the process of accession discussions for a long time, and that's now been joined by this very pressing geopolitical need, the salience of the Eastern European member states, most prominently Ukraine, but also Moldova, Georgia, who have now joined in this enlargement process. And so we now have the first example of states that wish to acquire not only member statehood in terms of international law, but also the nationals of that state are looking to acquire EU citizenship, and they're doing that in full knowledge of the fact that EU citizenship itself can be extinguished. But I think it's very interesting that this situation in which there are nationals of states who want to acquire EU citizenship That can be argued to be closer to Habermas's idea of this hypothetical constituent assembly, because we can think of these processes going on at the national level. So Ylenia mentioned since 2019, the Ukrainian constitution. This can be seen as that constituent discussion about deciding to adopt a new status altogether and then join with those who currently hold EU citizenship. And so if we take this view of accession as really rooted in the individual and this decision that they make to acquire a fundamental status, I think we can look at the conditions for accession that are outlined in Article 49 TEU. And we can look at that condition that it's about states that are committed to promoting the values in Article 2 TEU and respect those values. So we can adopt perhaps a more sociological lens and even a meritocratic lens. And perhaps we could look at the situation in Ukraine. We could look at Ukrainians who have faced full-scale invasion by Russia. And at that level of constitutional merit, we could consider whether they may already be regarded as having become Europeans because of the sacrifices they've made in defending values such as democracy and ultimately self-determination from authoritarian invasion. So perhaps that can be seen as a sociological foundation for these processes of accession, whereby individuals then acquire the legal status and the democratic status of EU citizenship. And so in the thesis, I talk about how the dual constituent thesis can also be broken down into a quadripartite role, because individuals function not only as juridical objects of EU law, so they are the subjects of law that is created by the legislature and then applied by the courts of justice, but they are also crucially the democratic subjects of the order. I said before that they were represented by both the European Parliament and by Council of the European Union. And so looking at it through that quadripartite lens, we could look at Ukraine and we could consider there's already a strong basis actually for the quite unique nature of what it means to be a juridical object in EU law, based on the fact that the association agreement between Ukraine and the EU has quite strong provision for something approaching free movement rights. But then the acquis communautaire monitoring the adherence to each sector is crucial to guarantee that individuals can be in a position to be juridical objects, and also crucially that the institutions in Ukraine can apply EU law, especially as Ukraine does still face issues with corruption in its judiciary. There was a president of the Supreme Court who had to stand down even recently since accession processes began, and then this would of course undermine the EU value of the rule of law. And then I'd argue that since Ukraine has been accepted as candidate state, we've seen this iterative construction of Ukrainian individuals as democratic subjects, and that's been through this process whereby we've seen the increasing influence of Ukrainian politicians, most especially President Zelensky, in European fora. And then we've seen the start of these Ukrainian democratic representatives engaging in EU political processes, observing council processes, for example. And so I'd like, after those reflections on accession, to move to this third phenomenon of territorial secession issues. And here I think we can see this as concerning the other side of this dual constituent coin. I've talked a bit about what it means to become an EU citizen. This relates to what it means to become a member state as opposed to a fully independent state. This relates to what Polly was saying about how it's actually quite unique how much sovereignty is ceded, is pooled within the European Union. And I think it's interesting to reflect upon just how fully EU membership can change nationality and can also change some of the crucial features of being a sovereign state. I think one example from the current candidate states is the fact that North Macedonia is actually engaged in changing the name of its state due to concerns that were expressed by the current member states of Greece. And so we see that transformative effect of accession. But then for Ukraine, there's probably a graver relevance here in terms of territorial integrity and territorial secession. And this, of course, concerns the possibility that in order to guarantee a peace settlement with Russia, Ukraine may have to accept certain secessions or perhaps more appropriately annexations in that peace settlement. And how would accession to the European Union cope with this new reality? I'm thinking, of course, of areas of eastern Ukraine that are occupied by Russia and also Crimea. And I think here that the narratives of disintegration and disruption that I cover in the book can be very instructive. There are somewhat similar situations, but without it being as geopolitically dramatic as armed invasion. So, for example, in terms of this idea of disrupted integration, which is more usually called differentiated integration, both the UK and Ireland had opt-outs from the Schengen zone. It was important, it was necessary for individuals to show their passports to enter these frontiers. Now, that was a decision that was made by the United Kingdom government on the basis of their executive preferences. But for Ireland, I'd argue that they were compelled to engage in this opt-out because of the fact that there was an imperative to prevent a hard border between Ireland, the Republic in the south, and Northern Ireland, which is part of the United Kingdom, and to ensure that the common travel area could continue to function, because Ireland and the UK have their own passport-free zone. And perhaps an example that's even more appropriate is Cyprus. We have an example where, because of occupation of the northern part of that island, Cyprus also benefited from a derogation from the Schengen zone. They are not obliged to apply these Schengen norms. And so these examples can perhaps open up possibilities for a form of differentiated or disrupted accession or integration for Ukraine. And so the issue I mentioned before regarding Northern Ireland and Ireland, which can be seen as the closest the UK has come to a secession crisis in tandem with Scotland, which I know John will discuss, can be instructive. So when we're considering exactly how Ukraine may accede legally to the European Union, we may consider some form of reverse Windsor framework, or it used to be called the Northern Ireland Protocol, whereby the Ukrainian government may be exempted from the requirements to apply norms such as the Schengen zone. Norms because of the fact that there is not full territorial cohesion because of these secessionist pressures. And I'd like to conclude by returning to the individual level, that level of the person, the role they take on as constituent citizen of the European Union, as well as being a member state national. And again, the legal frameworks that were constructed to deal with secessionist pressures in Ireland and Northern Ireland could be instructive here again, so for the future, because the Belfast or Good Friday Agreement, which resolved the troubles in Northern Ireland, provided an option to anybody who was born within Northern Ireland, so a constituent nation of the United Kingdom. They had a choice whether they wished to be a UK citizen or a citizen of Ireland. And that has now become an extremely interesting, quite unique point post-Brexit, because we have a situation where individuals born within the United Kingdom or one constituent nation have the opportunity to actually reacquire EU citizenship. And so I wonder whether we could look at a similar kind of option being transposed for Ukrainian citizens. So regardless of the territorial settlement that may occur, if there is a situation in which territory may be seceded, may be annexed to Russia, if there were a similar kind of arrangement here, whereby any person born in these territories had the option of acquiring Ukrainian nationality, even if these territories were, in terms of the sovereign, in terms of who had sovereignty, part of the Russian Federation, then there could be an option for future generations whereby individuals born in these territories could have a chance to retain Ukrainian nationality and thereby acquire EU citizenship, thus allowing that promise that was offered to these people of being able to become European constituent citizens to be realised. So thank you so much. I'd be very interested to hear any thoughts you may have in connecting these three phenomena together. Thank you.
Thank you, Oliver. So we have added some more elements for our discussion. Now it's the turn of our first discussant, John Stanton. You have the floor. John?
Hello, can you hear me?
I can hear you.
Yeah, excellent. Yeah, I'm just trying to. Sorry, not very much luck here.
Your webcam is turned on.
There we
Okay,
go.
now
There we
we
go.
can also see you.
Excellent. Thank you. Excellent. Well, thank you very much for having me. Thank you for the interesting contributions. And my my contribution sort of takes a kind of a different stance in the sense that I'm looking, as Oliver mentioned, specifically sort of the way in which Brexit has impacted on the sub-national level within the United Kingdom. And this is something that, I mean, in chapter 4 of Polly's book, she talks a lot about the Northern Ireland, or the issues surrounding the Northern Ireland Agreement, and what that means for people in Northern Ireland going forward. I suppose my starting point really is to kind of link this back to points that both Oliver mentions in his book and Polly has mentioned already today, that the democratic legitimacy of Brexit is interesting because, as we all know, the result, of course, 52% voted leave, 48% voted remain. EU residents in the UK couldn't vote, except, of course, the Irish, who have their own arrangements within UK legislation. And then, of course, UK residents in the EU weren't allowed to vote if they'd been off the electoral roll for 15 years. So there are plenty of issues regarding the way in which Brexit happened, affecting people who didn't perhaps get a legitimate say in the outcome. And this is also true at the subnational level, because the devolution arrangements, the way in which the United Kingdom is broken down to England, Scotland, Wales, and Northern Ireland, presents an interesting perspective when we look at the statistics for Brexit votes in those areas. So in England, 53% voted to leave. In Wales, 52% voted to leave. In Northern Ireland, only 44% voted to leave, so 56% voted remain. And in Scotland, 38% voted leave, so 62% of the Scottish nationals voted to remain in the European Union. And this last one is particularly important because there are sort of two significant developments that have happened during and post-Brexit that might be categorised as Scotland trying to reimagine the way Brexit applies to Scotland, and also perhaps even to try and stop Brexit from affecting Scotland, as I shall explain. Obviously, these statistics they're interesting, but of course they did not stop Brexit happening. Of course, Brexit took a UK-wide vote, but it does. These issues are important both for as I said, the way in which Brexit works in the regions, but also the way in which Brexit has also taken effect and the way in which the relations between the different parts of the United Kingdom have been affected by Brexit as well. But before I get into that, the very brief overview of devolution in the United Kingdom for those who aren't familiar with it. Devolution, the transfer of power to Scotland, Wales and Northern Ireland, came into effect in the late 1990s. The whole purpose of this was to give new institutions in those regions legislative and executive powers to make laws, make decisions for the people in those regions. It was legitimised by referendums. It was given effect by legislation. There is an inherent asymmetry in the arrangements. Scotland's always perhaps been the strongest devolution package, insofar as it's had the broadest areas of law in which the Scottish Parliament can pass laws for Scotland. Wales now has as much power as it's ever had, but at the very beginning it was a very thin conception of devolution, a very thin package in that sense. Northern Ireland has, in terms of the strength of the package, Northern Ireland is somewhere between the two, but the continuing political troubles in Northern Ireland have complicated the way in which devolution has taken effect and the way in which it works. So with this in mind, and recalling that in Scotland, 62% of citizens voted to remain in the European Union, and bearing in mind, of course, as I said, it's the strongest devolution package, both politically and legally. It's always perhaps been the biggest thorn in the side, should we say, for the UK-wide government. And this compounds this statistic, the 62% that voted to remain compounds this issue, and I think does present an issue, particularly when we keep in mind, if we go back 2 years before the Brexit referendum, if we go back to 2014, September 2014, there was a referendum in Scotland as to whether Scotland should remain a part of the United Kingdom. That referendum was closer than a lot of people thought it would be. 55% voted to remain, 45% voted for Scottish independence. The consequence of that vote was that Scotland would remain, of course, as part of the United Kingdom, but the UK government gave to Scotland, as a consequence, an even stronger devolution package. Further powers, particularly tax-raising powers, were given to Scotland. The political permanency of the institutions was declared in legislation. And crucially, and it was said on all sides, that the independence referendum in 2014 had settled the question for a generation. It had settled the question for a generation. Not for at least another 50 years or so would we ever consider or entertain the question of Scottish independence. And of course, 2 years later, the UK leaves the European Union, with a majority of the Scots voting in favour, a significant majority of the Scots voting in favour of Remain. And we can almost see where this is going, with that last point, particularly about the independence referendum being the last time for a generation we ask the question, because it has categorically not been the last time that issue has come up. So this cuts right to the heart of a rather uneasy legal and political situation. In terms, and sort of dropping back to the brief overview of the way devolution works, the way in which Scotland was to be taken out of the European Union relates to the way in which laws passed by the UK Parliament still affect Scotland. So as I said, Scotland, along with Wales and Northern Ireland, has legislative powers in certain areas over the people of Scotland. The way that this is arranged is that it protects the sovereignty of the UK Parliament. So in the devolution statutes, there are lists of what we call reserved powers, certain substantive areas that are the sole responsibility of the UK-wide Parliament, reserved matters on which Scotland, Wales, Northern Ireland cannot legislate. Now, by using the reserved powers model, the legislation is in no way limiting the power of the UK Parliament. That was crucial. That was always intended, because if they'd said, well, the UK Parliament can no longer legislate in these matters, those have been sent to Scotland, then the sovereign Parliament would no longer be sovereign. You'd be limiting its sovereign powers. So this reserve powers model was designed to protect parliamentary sovereignty. Anything not reserved was presumed to be devolved to the nations. That was the legal reality. The political reality that sits alongside this is a convention, the Sewell Convention, which states that Parliament, the UK Parliament, will not normally legislate for the regions without their consent. Okay, but that's a political convention. It's not a legal rule. If it were a legal rule, again, Parliament would no longer be sovereign. So the reserved powers model is the legal instrument that keeps devolution together and the UK together. The Sewell Convention is the political instrument that protects devolution from the power of the sovereign Parliament. This is relevant because the European Union Withdrawal Act 2018, an act of the UK Parliament, which was the definitive act. It repealed the legal repeal of our membership of the European Union. It touched upon devolved matters. Yes, of course, on a much broader scale, it was fundamentally constitutional. It was matters reserved for the UK Parliament. But such is the breadth of the legislation, it also touched upon matters that were devolved to Scotland, to Wales and Northern Ireland. This being so, the Sewell Convention is invoked, and Scotland should have consented to the passing of that act, but it didn't. Scotland refused to consent to the passing of the European Withdrawal Act 2018. But it was passed anyway, and it was passed anyway because the Sewell Convention is a political rule, not a legal one. That political rule does not change the ability of the UK Parliament to pass that law anyway without Scotland's consent. But Scotland, having not consented to the 2018 acts, assumed wrongly that the form of Brexit enacted by the 2018 Act would not take effect in Scotland. Scotland assumed that it could therefore be left to determine its own form of Brexit exclusive to Scotland. In particular, it wanted to provide for EU law to remain in effect in relation to devolved matters, giving the Scottish ministers their own powers separate from the UK to adjust these devolved EU matters in the light of Brexit. In other words, to determine for themselves the laws, the EU laws that would remain in effect in Scotland. This was the legal continuity bill, and inevitably it was tested in the Supreme Court. Scottish Acts of Parliament, because the Scottish Parliament is not supreme, the Supreme Court has the ability to review their legitimacy. In the Supreme Court, the question was simple. Was the legal continuity bill within the legislative competence of the Scottish Parliament? Did it have the power to pass that law? And the answer was no. The answer was no. Whilst they were seeking to protect retained devolved EU law, the areas that are devolved to Scotland, crucially, clause 17 of that bill sought to prevent legislation passed by the UK Parliament in relation to Brexit from coming into effect without the consent of Scottish ministers. So they were essentially seeking to galvanise their own image of Brexit by saying anything passed by the UK Parliament from this point relating to Brexit can only take effect in Scotland with our consent. And that simply was not constitutionally possible because it would limit, Scotland would be seeking to limit the power of the sovereign parliament, which goes against the devolution statutes and fundamental constitutional principle. So the Scottish Parliament, in seeking to pass the legal continuity bill, would be acting beyond its competencies, said the Supreme Court. So this case, therefore, ensured that despite the referendum result in Scotland, despite their attempts to take their own Brexit deal in their own direction, they did not constitutionally have that power. So what was the next question? Well, I said earlier that the independence referendum settled the question for a generation. Just 5 years later, Nicola Sturgeon, the First Minister in Scotland at the time, she formally requested from the UK government a second referendum. This was denied. Theresa May said, we've got to focus on getting Brexit done. We're not interested in the question of Scottish independence at this time. The Scottish government nonetheless proceeded with plans and introduced legislation. Scottish Parliament introduced legislation which made provision for a second independence referendum in 2023. Now, again, we end up in the Supreme Court because the question here is, can the Scottish Parliament unilaterally legislate for an independence referendum? And the answer was no. One of the reserved matters listed in the devolved legislation is the Constitution, and specifically the Union, and I'm quoting here, the Union of the Kingdoms of Scotland and England, a reserved matter. So Scotland cannot unilaterally decide that we want an independence referendum and break up the United Kingdom without the UK's involvement. So in that sense, and as a result of all this, Scotland has, along with the rest of the UK, been dragged out of the EU, kicking and screaming, it would seem, creating and giving rise to some sort of key thorny constitutional questions which were tested in the Supreme Court. Just 3 weeks ago, there was a headline where Keir Starmer said there's no independence referendum while he is Prime Minister. And what is also significant is that when we had the first independence referendum in 2014, there were 56 Scottish National Party MPs in the Houses of Parliament. There are now just 9. So we could very much say that perhaps the political momentum which drove along this independence vision has perhaps died down. And I think the question is at least settled for the time being. But I don't think we have settled the question for a generation at the very least. It's an ongoing discussion. Another part of the United Kingdom, which Polly and both Oliver and Polly both mentioned, Northern Ireland, of course, is an interesting case because obviously there's a land border between an EU country, the Republic of Ireland, and the UK, the Northern Ireland, and this has implications for the imported goods because the UK, as we know, it left the single market, it left the customs union. Standard rules would say goods that imported are subject to customs checks at this border to ensure that all applicable tariffs are paid, etc., that goods meet the relevant standard, etc., etc. checks such as these would, most parts of the world, be carried out at hard borders. So that was the first question. Are we creating a hard border between Northern Ireland and the Republic of Ireland? This was a dilemma because a hard border would have compromised the Good Friday Agreement. The Good Friday Agreement, the work of when Tony Blair was instrumental in seeking that agreement back in the late 1990s, devolution to Northern Ireland was contingent upon that agreement, because the agreement says quite simply, Northern Ireland will remain a part of the United Kingdom until and unless the citizens of Northern Ireland vote in a referendum to become part of the Republic of Ireland. It leaves the question with the Northern Irish people. So imposing a hard border between Northern Ireland and the Republic of Ireland would essentially be taking away, or making it, at least making it a lot harder for that vision to be realised were it ever desired. So there was no desire, no inclination at all to put a hard border between the Northern Ireland and the Republic of Ireland. And this is where the Northern Ireland Protocol came in. And it is essentially, and it has been changed since with the Windsor Framework, the Northern Ireland Protocol effectively ensures that certain EU customs remain in force in Northern Ireland, effectively creating a hard border down the Irish Sea and between Northern Ireland and the rest of the UK. This is given legal effect in the UK Internal Market Act of 2020. But the result of this is that Northern Ireland is subject to different customs arrangements from the rest of the United Kingdom, different trade rules. And because it is certain EU customs remain in force in Northern Ireland, the Northern Irish institutions, people, representatives have not had a say in determining those rules because they're no longer a part of the European Union. There is one slight allowance for this so far as the Northern Ireland Assembly has to consent for continued application of the rules every 4 years, and it's just given its renewed consent for that. But it does raise the question: has Northern Ireland left the European Union? Because so many of these EU rules and UK rules are applicable in Northern Ireland. And I'll leave you with this. It's to be frank, it's rather comical. There was Rishi Sunak, when he was Prime Minister, went over to Northern Ireland to try and sell the trade deal as all this was being stitched up. And he said, despite the fact he'd pushed Brexit through, he said to the Northern Irish people, you are in the best position in the world because you're part of the UK and you've got all our trade arrangements and you're part of the European Union, which kind of raises the issue, as I said, has Northern Ireland left the European Union? And if Northern Ireland's got such a good deal, then why haven't we got that deal? So it does raise questions both politically and legally. But essentially, teasing all this out, devolution has been a fundamental thorn in the side for the realization of Brexit, but equally Brexit has, I think, compromised the strength of devolution, and we'll see in the years, decades to come, the consequences that this will have. Thank you very much for listening.
Thank you, John. This is a crucial point. The United Kingdom, just like many other states that are currently member states of the European Union, has a complex subnational structure, but asymmetry and flexibility are a distinctive feature of the territorial organization of the European Union that can be found out even elsewhere, but not with, let's say, the same degree of complexity and ingrained in such a complex constitutional structure with basically the sovereignty of Parliament and other principles of the unwritten constitution. And of course, this has had an impact on the handling of the Brexit. Now we have our final speaker, Dr. Andrea Gatti. Please.
Good morning, everybody. Thank you, Giacomo. Thanks, first of all, to the organizer, Ylenia and Giacomo. It's not easy to joke after this presentation, but I'll try to tease out a common thread to run through them. I will take in consideration, in particular, one of the three concepts that was on stage today, the disintegration of the European Union, particularly the importance of considering the EU's constitutional values in the process of withdrawal. Well, I believe that this fil rouge lies in concept that, while never stated outright, never explicitly mentioned in all the presentations, was nonetheless always present. Concept that, as Giacomo recall, I'm familiar with, and this is the militant democracy. So I ask myself, can Article 50 and other measures prevent dissolution be interpreted through the lens of militant democracy? So, to prevent dissolution through this interpretation, and if so, how? And what is militant democracy applied to disintegration, first of all? So, for those that are not that familiar with, I think that more or less everybody knows what we are talking about. Militant democracy is an answer to the question of how liberal democratic system might legally defend itself against internal actor that aim to dismantle it. So militant democracy is not just self-defense, any kind of self-defense, let's say so, but a rights restrictive self-defense. So its particularity lies in restricting political rights. We talk about European Union, Council vote, party registrations, etc., etc. So the first step, the first etymological problem is to assess whether the Union is or can be classified as militant democracy, especially given the supranational nature and the coexistence of this supranational nature with the national constitutional orders, as Professor Garner stressed. I've been convinced that by Oliver's view that EU's material integrity is not defined by a fixed territory, but rather by shared values shown in Article 2, and also procedure protected by Article 7, view that aligns very closely to what expressed also Professor Polak and Professor Citino, Ylenia. The second step is to assess what interest it seeks to protect through such characterization. Thirdly, we must evaluate whether there is any militant tool envisioned to prevent or manage withdrawals. And fourth, whether from a militant perspective, that the withdrawal itself could be suggested unconstitutional. So, European Union as militant democracy was explored already by prominent scholar, Miller, Wagner, Pfizer, also Martinico, one of our kind guests. But facing it, this concept with the categories that we analyze today, we can isolate 4 measures that are consistent with our reasoning. The first one is the infringement proceedings against the member state, Article 258 until Article 260. These procedures, these mechanisms do not interfere with political participation, even if it's a sanction. So it doesn't touch the paradox of militant democracy. I wouldn't consider it. The second measure is the rule of law conditionality regulation, Regulation 2092 of 2020, that we all know. Even in this case, the substantial of the EU funds not impair the political participation within the EU institution. So even these measure, I wouldn't consider as a measure that we could take in consideration today. And then there is Regulation 1141, 2014, which governs the registration, the oversight, and sanctioning of European political parties. This is a little bit more interesting because what said that registered parties and parties that want to register, so even in a preventive perspective, must commit to the respect of EU fundamental values, Article 2 of the treaty, that it might be a deregistration of the procedure, but we are not interested in today right now. But it might be a deregistration made by specific authority if those parties don't align anymore with these values, and in this case we can say that given it's directed to political entity, the exclusion of the founding of the registration, founding that follows the registration, significantly distorts political equality amongst the forces, the political forces. So this is something that we can take into consideration. And then Article 7, of course, probably the most used, quintessential militant democratic tool, no? That enables sanctioning in member states that violate fundamental rights. Even in this case, there is a direct intervention in equal political participation at institutional level. So we can reasonably conclude that both by nature and by the existence of certain instruments, by nature that was stressed by Oliver, so the existence of this instrument, of this tool on 4, the European Union can be qualified as militant democracy. And so we can find the protected interest that and one of the protected interests is also the protection against disintegration. So we know that there is at least scholars find at least 4 different forms of disintegration. The output protocols that also recalled today by Professor Garner, Ireland, Denmark, etc., etc., etc. In this area, we know the revocation. States agree to extract a specific element of integration from the treaty via treaties amendments, the withdrawals, and the dissolution. All the members still jointly agree to dissolve the European Union. So this is interesting, and amongst all these forms, there is no mechanism for expulsion of member states. One bit I could get in a while. It stays on the withdrawals. Both Professor Garner and Professor Polak basically distinguish between disintegration through withdrawal, which might be legitimate, from illegitimate means of disintegration, such as judicial determination that EU values do not apply to member states. And indeed, from a legal constitutional standpoint, withdrawal poses a particular challenge for militant democracy. Why? Because it's not certain that the necessity condition, which is a key criterion in militant democracy to apply democratic measures, those that are extrema ratio, so this necessity condition could be even met, given the voluntaristic nature of EU membership, trained in Article 50. So, the question of what extent should the democratic will of a member state be constrained by EU legal order values during the withdrawal process, I think we can ask whether that tension between values and sovereignty can justify a reinterpretation of Article 50 as being subject to the same foundational values of Article 2 of the treaty. Or maybe even better, should Article 50 be reformed, the timing procedure requirement integrating Article 2 values explicitly. In my opinion, this is not just desirable, not just possible, not just desirable, but also necessary in the situation we're living in to preserve the internal coherence of the EU legal order. Although the deep tensions between national sovereignty and supranational constitutionalism tension that exposed the structure ambivalence of the EU as both as union of states and community of values. I see that as much as Professor Polak does, and also Professor Ylenia, Professor Citino made clear by the EU clauses in the member state, and I'm quoting here, the deep European constitutional legal order, there is a false dichotomy between democratic will and EU values. Actually, those are very different. But I think that the most pressing challenge that we are currently facing in the EU is not how to manage those member states that wish to leave. Because basically they don't want to leave. So rather is how, the problem is how to deal with those states that are not embracing liberal values anymore, so values according to Article 2 of the treaty, but that insist on remaining within the union, while simultaneously they reject these values. So this is the true dilemma. A structural and normative paradigm as militant democracy supposes that tests the effectiveness of the mechanism in place. And in this regard, some scholars have gone so far to theorize a radical workaround of the rule of unanimity, required from the treaty, through a kind of it's an interesting suggestion, a kind of a collective withdrawal of all liberal democratic states from the EU. So the states that continue to recognize themselves in the liberal democratic value withdraw altogether, all at once from the EU. So the EU remain as empty shell, only with subjects that are not sharing these values, and they're trying to recreate a kind of new European Union. This is a paradox, of course, a kind of a provocative suggestion. It's for what the means that we have right now. Opinion is one of the few options that we have, of course. So the atomic, the nuclear option, of course. So just to conclude, also with another provocative suggestion. The impasse that we draw calls for serious reflection on the need to amend the treaties, particularly to introduce explicit mechanisms for expulsion. A reform in this sense, what would you, or which kind of benefit will take us? Mostly free. It would remove the influence of autocratic government, illiberal with the union, from all the legislative and political process. It would protect the democratic character of the EU itself, and it would not entail significant democratic costs, even if it's a nuclear option. Why? Since the expelled states are, by definition, already degenerated into non-democratic regime. There is not a democratic impact, given there is no democracy. Of course, it is a provocative, again, a provocative suggestion. But I think I really think that at least on a theoretical level, the possibility of expulsion should not longer be in the EU constitutional discourse. If the union is serious about defending its values, it should do this not just reactively, so as a matter of emergency, but structurally, which is the way of militant democracy works. Thank you.
Thank you, Andrea. Now we have some time for comments and questions. I have written down a couple of remarks that build on the presentations given by our main speakers and the two discussants. My first remark has to do with the fact that by now, thank you, Pauline, I have noticed it. By now, we need a comprehensive understanding of Article 2 TEU. In the last 15 years or so, public attention has been sort of monopolized by the rule of law, by the need to address constitutional backsliding, mostly in Central and Eastern Europe, and to focus on deviations from a, let's say, European paradigm of the rule of law. This morning, the interventions, the presentations have highlighted that Article 2 is about something more than just the rule of law. So much has been said about democratic requirements. The focus on the subnational architecture of the United Kingdom reminds us of, say, on the one hand, the protection of national identities, including regional government, but also the issue of internal minorities, which is, of course, a quite important issue in the global constitutional conversation about secession, starting from the Canadian reference on Quebec secession. Another remark, let's say a question, has to do with, so Oliver has mentioned the Big Bang enlargement 20 odd years ago. What about accession in the present setting? So what does it entail by now applying for membership of the European Union, let's say, against political constraints and the perception that, let's say, concentric circles, great asymmetry may sooner or later become a reality in the EU's constitutional landscape. Polak.
I have a few questions. I basically have one for everybody, so I don't know how they're going to answer me. But well, Ylenia, I already mentioned that I was interested in her telling us a bit more about what national constitutional clauses say about withdrawal, which I believe is nothing or little, and how she envisages, like the UK did, how they fill that gap, asking the UK Supreme Court, does she envisage every member state having to ask their constitutional courts how to withdraw? Because she also mentioned something about you'd have to reform your constitution before being able to withdraw from the EU. So I'm not sure if I understood that correctly, but I'm very interested in that idea, if she could explain that a little more. Then to Oliver, it's more of a comment than a question. Oliver is interested in how citizenship has sort of maybe evolved negatively after Brexit, because now it has been established that it can be extinguished. I tend to have a more positive view in general, and I've also thought about this because I was asked to write a little article for EU Law Live on how citizenship has evolved post-Brexit. And my idea was that, well, we all knew that it was dependent on member state nationality. So that's not sort of revolutionary. But what I think that we might have learned in a more positive terms from Brexit is that even though you can extinguish EU citizenship, you can't extinguish certain rights attached to EU citizenship, because that was the whole basis of Brexit, was to eliminate those rights. And in the end, we have a withdrawal agreement, and one of the main blocks is how to protect those citizenship rights that are being exercised now at the time of Brexit. So I thought that that was maybe more of a positive view. And then, John, I have a very quick question regarding the settlement of these big questions in Scotland has been settled for a generation. So my question is, do you think Brexit has been settled for a generation? Or will there also be another referendum around the corner on that? Or are we not going to ask them ever again? Because the answer might be different this time. And Andrea, very interesting. I'm going to just defend my working paper, because obviously he at the end mentioned this isn't the right question. What if these member states want to withdraw and they don't do constitutionally because they don't? That's very provocative. I liked your presentation. It was very provocative, many things of it. But I think nobody thought the UK was going to leave either. So I wouldn't totally discard the possibility. And also, why don't they? And everybody always says, well, because they get a lot of funds from the EU, no? So these governments, they might not be interested in the values and in the integration project, but they're interested in the money. But now we have a conditionality mechanism that is cutting the funds, no? So if you're not sharing the values, we're not allowing your own vision of values to penetrate the EU. The Court of Justice is consistently punishing you, the Commission is punishing you, and you're not getting the money either. Is it true that they might not decide to withdraw someday, or at least to threaten to withdraw? Thank you.
Thank you, Polly. Camilla Gaddis. Please, if you...
So, thank you for all the speakers, both who are online and in presence with us in Pisa. And I'm a postdoctoral researcher here at Sant'Anna, working mostly on migration and asylum issues, but also on constitutional law issues, and I happen to be Hungarian. And also to know the whole story, also from the internal constitutional perspective. I have two questions for the presenters here in Pisa. One regards the accession part, and the other one regards the militant democracy part. Regarding accession with respect to the Western Balkans, also Ylenia made reference to this deep entrenchment, the deep commitment that these countries show towards the EU, if you look at the constitutional structure. But from the other side, so let's say a more politological, politically scientist perspective, and also from a geopolitical perspective, the whole accession phenomenon, I wouldn't say process because it might be too much in the Western Balkans. It's really determined also by geopolitical forces, Russia, Turkey, China present, and the EU who has to compete with all these forces. And there was a political scientist who coined the term stabilitocracy, referring to some of the Western Balkans structure that towards the EU, they present themselves as a sort of facade democracy, but behind this facade, we have a lot of issues. And to the extent to which they really comply with all the requirements under Article 49 TU raises some concern, let's say that. And the EU also, precisely because of renitent member states, sort of engaged in a stop and go politics in all these 20 years or so. So in light of this, what would be the role of all these constitutional clauses, or what would be their actual relevance, or how would we consider in front of this reality, which is not that very, let's say, promising. The other question regards the term militant democracy. So first of all, so you said that the EU can be classified as a militant democracy, right? So am I correct? Okay. So how, because if democracy entails also a sort of decent treatment of those parts who are not its constituents. So I'm thinking of third country nationals, stateless persons. And if you look at the new pact on EU migration, the new EU pact on migration and asylum, the EU sort of lowered all its standards or its protective standards vis-a-vis all these people. So if democracy entails a decent treatment of who is outsider, how can we classify the EU as a militant democracy if it does not treat decently the people stranded in Lampedusa hotspot, in Taranto, in Greek islands, at the external borders, in Poland, in Hungary? So, and also, in here I also joined to Professor Polak's remark on the derivative nature of EU citizenship. So also and its indirect impact on all those who do not have a citizenship of one of the member states. Because I'm not so sure that the EU can be really classified as such. And another question regards this self-defensive nature of militant democracy. So you told, if I'm correct, and please correct me if I'm not, that militant democracy is self-defensive. So it's trying to protect itself. Can we go beyond this self-protective nature? Can we reconceptualize it in a more assertive, not aggressive, assertive way? So can we some room for that? Can there be some room for a more, I don't know, militant way? Because militant is more proactive. Yeah, proactive, yeah. And concerning the need to amend the treaties and insert an expulsion mechanism, how would you assess that there is no democratic cost? Because if we look at, for example, of course, Hungary is the most blatant example. And if you look at the internal, let's say, dynamics, yes, it's an illiberal democracy, and it's on the slippery slope of autocratism, authoritarian regime. I don't deny that, also because I know what's going on. But there are other parts. So the picture is more nuanced, it's more complex. So you cannot say that, okay, just because Orban is authoritarian and 1/3 of all active voters, because he is supported only 1/3 of all active voters. It's another question that with that 1/3 of votes he can do an authoritarian regime, because of course he hijacked all the electoral process. But there are also other forces. So expel a member state just because one part of its constituencies is authoritarian seems to be a bit too much. But if it was about, if it were about Poland or Slovakia, I would say it's the same thing, not because I happen to be Hungarian. But, and also, what about the other concerns? And Brexit in this remark was pretty instructive. And I think that after Brexit, no one wants to leave. But not because of the EU values, but because of all the practical implications of Brexit, both from the EU side. That's clear about that. But how would you consider all these practicalities, such as the Schengen zone? So, for example, if we want to push, if we want to expel Hungary, there is the Schengen zone. What do you do about that? So, especially if Ukraine then joins the club. So Hungary would be sort of, yeah, an enclave, yeah, except for Serbia. What? Switzerland. Okay, so it's just, these are my remarks, and sorry if I have taken too much time, but all the presentations were really inspiring.
Thank you. Thank you. Any quick suggestion? Yeah, quick suggestion. Lorenzo De Carlo, another doctoral student at the Scuola.
Good morning, and thank you for all your relations. There's just a quick suggestion, a quick idea. Usually, when thinking about pro-independence movements inside the EU, like Catalonia, Basque countries, but even Scotland when the UK was a member state. Usually the role of the EU was like quite nuanced. They almost always supported like the unity, pro national unity tendencies, or like in the Scottish case, they respected the open position of the of London government towards Scottish with the referendum and so on. But nowadays the pro-independence movements look like in a worse state compared to 10 years ago. Some of these movements have decreased their consensus, their impact. But I'm thinking about this possibility. Is there a chance that the EU can become like the place where pro-independence stances can be tackled, can be discussed, and can be in some way not necessarily contained, but using in order to find an agreement between the parties, and if necessary avoid some struggles or harsh confrontations like it happened in Catalonia in 2017. Thank you.
Thank you, Lorenzo. In this respect, I would like to mention a monograph that was published by Oxford University Press a couple of years ago, Secession and European Law, the Differential Attitude, by Nuria González Campañá, who is also, I think, an alumna of Reconstitution, I'm not sure, and she makes a case for enforcing Article 2 regarding internal secession crisis in the current member states of the European Union. Now, I suggest that we follow the same order as before: Ylenia, Polly, Oliver, John, and Andrea. 5 minutes each, more or less. Okay. Ylenia.
So, thank you very much. I thank you all for your active participation in this seminar, and I will only address the question that Polly asked me about the necessity to go through constitutional reform in case a member state has to withdraw from the EU and has a full-fledged European clause in its constitution. Indeed, this was the core research question of my project in Luis. And we were asking whether this was a constitutional limitation to withdrawal. This is, of course, a question that does not have a universal answer, because it all depends on the distinctiveness of each legal order. So during my research, I specifically focused on Italy, and my conclusion was that given the irreversible transformation that the integration into the European Union has brought into the Italian legal order, and the fact that this transformation brought into our legal order new constitutional rights for the people, for me and for, let's say, minoritarian doctrine in Italy, this is considered as a constitutional core of Italy. The essence of the 1948 Constitution is the fact that we are part of the European Union, despite this was not the original intent of the article. So if one day Italy would have to withdraw from the EU, well, it would be necessary to change all the references in the Constitution, and change at least the interpretation given to Article 11, because I said that the article does not have a specific mention of the EU. Otherwise, any kind of reform that decides for the withdrawal could be deemed unconstitutional by the court. So this could be the case also for other countries. So, well, a research question, a future research question, future reflection could be to identify and study also other legal orders to see whether such European clauses mandate for a constitutional reform. Changing a topic, I wanted also to ask a question specifically to Oliver. And I'm really interested in what you mentioned concerning Ukraine is the sociological foundation for the process of accession. So I wanted to know more about this, like what do you refer to as sociological foundation, and what is the impact on the legal framework of the country and of the accession process overall? Thank you.
Thank you. Polly.
I'll be really quick because I already took up my time. I think I just wanted to add to the last question on if the EU could become a place where pro-independent movements could be discussed and resolved. I also read and actually wrote a review of Nuria's book, which is very interesting, the differential attitude towards secession inside the member states. That differential attitude means basically that the EU, yes, has to comply with Article 2, as Giacomo mentioned, but she also gives a very big role to Article 4.2, to national identity. And basically what she says is that if that independence is not constitutionally recognized or possible within the domestic legal order, then the EU would have to simply respect that position of the constitutional legal order of the member state. So therefore, if Scotland, for example, became independent, obviously, when Britain was still a member, or if any, they returned, and then Scotland became independent, then the EU would basically have to accept that because the British constitutional order accepted it. But if Spain doesn't accept the Catalonian secession, then EU has to respect that position. And that was the idea. Okay, I'll send the word back to you.
Thank you.
Yes, thank you so much, Sheila, for your questions. I think my answers can connect some of them together. So I think, Giacomo, what you were saying about what does it mean, accession at present, the political constraints, and Camilla, you mentioned the geopolitical situation. That's obviously, the Ukrainian war is one point, but of course there are others, and I think we consider this more global polarization between growing autocracy and the attempt to preserve liberal democracy. I think my answer would probably take in your question there, Ylenia, about the sociological foundations. I think it's possible to be slightly more critical. I think we can look at the decision that was made very early on in the full-scale invasion by Russia of Ukraine to give Ukraine candidate status. I think that can be seen as a symbolic geopolitical statement as much as a reasoned assessment of the readiness of Ukraine as a member state for EU membership. So, Ylenia, you said there, what does this sociological foundation mean? What's the impact upon legal accession? It can actually potentially be seen as something a little bit dangerous, the fact that because there is this sense of the merit that Ukrainian citizens have shown in their battle for democracy, it can be seen. Does that mean that there could well be shortcuts taken when it comes to ensuring that the acquis communautaire is complied with? There's an interesting anecdote from the past that I heard from somebody once saying that there was an EU official who said Greece had to be in the euro because the symbol of the euro is a Greek symbol. So you see here this symbolism perhaps playing more of a role over practicality. And then on this point that, Polly, you made about citizenship, it's strengthening the fact that it seems clear you can't extinguish certain rights. I'd say there, I agree with you very strongly, and it's actually one of the reform proposals I make in the book is about how the withdrawal agreement showed that the rights that have been acquired by individuals within a member state that's either withdrawing or by those citizens in another member state became such a red line in negotiations that my argument was that Article 50 should actually enshrine them. It should be clearly enshrined. And actually that led to a question I have for you, Andrea. So you made the point there about an expulsion clause and the fact that it may not have the democratic costs we think because of democracy being diminished in the member state. My question is, what about the individuals who may regard themselves as EU citizens still? And I wonder, could there be a similar kind of mechanism of expulsion whereby the rights of those individuals are still preserved, or there's even a means for them to reacquire EU citizenship, for example, through becoming a national of another member state? I really like the point you make, Camilla, about after Brexit, no one wants to leave. These practicalities, I think it's very telling that you used the Schengen example, because another argument I make in connecting disruption through opt-outs and withdrawal is the fact I wouldn't make a causative claim that the UK's opt-outs are what led to withdrawal, but I think it facilitated the conditions whereby withdrawal would not be as disruptive as it might be, for example, for a member state that had full integration. So the fact that already UK citizens were having to show their passports to go to the EU, the fact there wasn't the currency being used, and of course that's very different for other member states. But something else I find fascinating is we, in a sense, have a challenger model to supranational integration now. We have what can be seen as this more democratic intergovernmentalism model, the new EU-UK Trade Cooperation Agreement. And I have to admit, when I saw the recent EU-UK summit in London, I was thinking, I'm sure that Viktor Orban would love this. The fact that, him being there as an equal to the President of the European Commission, the President of the European Council. So I think something really interesting to track over the next years as the UK relationship develops is this going to look more attractive to those heads of state or resistant member states as we see it develop, and especially as we see potential concessions being given to the UK as part of this reset. And then as a final point, I'd say, Lorenzo, your point on secession. What I find interesting is there is perhaps one of the little-known institutions, the Committee on the Regions. And I wonder whether the Committee on the Regions could be an interesting forum for such discussions, because you might have a situation where representatives of the Basque Country, representatives of Catalonia, representatives of other regions where there are secessionist pressures can come together in a European forum and they can actually exchange on these issues and do that within an EU institution. So I wonder if it's worth looking more into how this institution could be used in the future. So thank you so much for your questions, and it's great to be able to connect all these different things together. Thank you.
Thank you. John, you had the floor.
Excellent. Yeah, thank you. Yeah, I'll be quick because I'm just coming back on Polly's, Polly's very good question. Has Brexit been settled for a generation? It depends what we define as a generation, I suppose, to be facetious. But I want to say yes. I think it probably has. First off, I'll say if there was a referendum tomorrow, I think the result will be different. I think such as numerous factors have changed, and I think it would tip the other way at this point. Well, it is interesting, this new deal that Starmer has struck with the EU. It was just the criticism of that deal from those who voted to leave highlights that it's still a very politically sensitive question. So I think if anyone was to campaign for in a general election to have a rejoin referendum, I think that would sink like a stone. It would be so divisive that it would sort of reignite kind of the political tensions that define the Brexit era. I think so. I think we need to wait for those divisions to kind of ease over a bit and for the general feel to change before we consider. Of course, we may, depending on the way the EU itself develops and evolves, we might find ourselves in it again. But I don't think that will be anytime soon, really. Sadly, in my opinion. But sorry, thank you.
Thank you. Andrea.
Few notes to add something what Ollie said. Yeah, this is interesting. It's also interesting, I didn't mention that, very often those states that invoke they resist EU intervention. They very often invoke their own national constitutional identity, as an obstacle against this external interference. This is something that noted amongst the other Jan Werner Müller the scholar that studied the concept of militant democracy, by the way. But, well, I think that this is quite fragile answer, the national constitutional identity, to pose the national constitutional identity as an obstacle, because as we stress also today, once the member state pool their sovereignty, they also committed to themselves, to the basic principle that must guide the exercise of sovereignty. I mean, I'm talking about the European Union. So, above all, democracy and rule of law. So, consequently, when a single state slides into the democratic backsliding, it contaminates the union itself. And this is how it's possible for the union to activate possible militant democratic measure, in my opinion. Then the question of Camilla about the asylum seeker. So the internal inconsistency of people that moved, immigrants in general. So the internal eventual inconsistency of the hypocrisy, we can also call it. Technically, militant democracy apply only to political groups or entity, like we can say states, but more specifically political groups or internal groupment of the state, not to individual. So I also answer to Oliver, it shouldn't apply to individual, at least in theory, because from individual don't come menace, don't come threats to democracy. From groups, because they're bigger, so there is a kind of also practical element, a single individual. So that's why individuals shouldn't be interested in democratic, in the militant democratic procedures. Yes, I don't agree with this position. First of all, because we have to for technical reasons, because militant democracy applies to group, and also because militant democracy doesn't mean that there is a duty to apply the values. We are not in an ethical state that the state has to apply this. Militant democracy means that there is a duty for parties, or mostly, or states also, not to violate the rule of law and the democracy. So it's different. So it's not something that you have to do, but it's something that you don't have to do. And plus, I personally think that it's difficult to say that the European Union, we violate democracy because we decided to strict immigration procedures. There, I think, are still probably the most advanced in the world, even after the reform. You were mentioned about the migrants policy. Maybe I got wrong.
Yes, if you do the new migration and asylum, several points of the legal acts and several provisions of these legal acts do not all those human rights, for example, those with the right safeguards that are also included in the activity, so dignity, but also the principles of sovereignty. So it's like, it's not about democracy, it's connected to the rights. And if you take out of the picture human rights, it's just what can be called.
Sure.
Come from the term demos. So if you take out
it's a matter of interpretation. Human rights, human dignity itself, it's such a wide concept. It's difficult to apply it in a way that embraces. Difficult. You can do this, but of course, and this comes from the second question. I come to answer to your second question. When you apply militant democracy, so when you apply the judgment of a behavior that might violate the democracy, so democratic principle, also human rights. There is always the judgment of the use of the proportionality principle. I agree, for example, that right now Hungary shouldn't be. It's not far, but it's. We shouldn't use the militant democratic measure because there are still a component of the society which I think it's minoritarian, but it's still like a component of the society. Well, at least so the elections are irregular, no? They have been fair, they have been manipulated, I think, in Hungary, and nobody says this. And Orban is still democratically majority. So it's, unless you say that they are manipulated, no. But if you see, if it stays on the fact, there is a democratic, the majority that support Orban, and Orban isn't on the way of altering the normal democratic functioning of the state. So this is just to say, I don't want to sustain one thesis or another. I'm just saying that this is also applied to the migrant issues. Always applying militant democracy with the matter of proportionality, with the principle of proportionality. So taking in consideration a wide range of interest, also kind of national security, and other kind of national, also collective interest. There is not just individual interest. Also individual interests are there. Let's talk about the case of 2017 or even 2024 that of the German Constitutional Court that also took in consideration the fact that these fascist party were spreading propaganda against single migrants, single minority groups, single people that belongs to the minority groups. So they took in consideration also, in this case, the individuality, but always in the big picture. That's why they didn't ban this party, for example, although they recognized that it was completely anti-constitutional and they were deserving to be banned, but they didn't. They didn't because there are other elements, criteria to take in consideration. One of them was the proportionality. This party was not strong enough to manage the threat, so we don't ban it. Yeah, and just last thing interesting, also suggested by Oliver, the relationship with the independent, Eduardo, this is Lorenzo, sorry, by you, the relationship between independence movement. It's interesting that normally those kind of independence movements look at the EU as a savior, not as a menace, because like the president of Catalonia, that's kind of asked for an asylum to Brussels. So it's interesting. EU, it's kind of a other kind of level that might just because it's far from, it might interfere in a good way with the state, local autonomies, territorial autonomies relationship. But this was just a suggestion. Thank you.
So thank you, Andrea. I will add nothing more, and I would just like to thank all of you, including Camilla and Lorenzo, for your insights. I'm closing the recording, and I will share with you the file, the resulting file. So thank you, and see you in Pisa or elsewhere for another discussion. Thank you.
Thank you.